But what I'd like to do is read this proposed order in. If you'll follow along, please notify me if you have any changes or thoughts. And you can wait till I'm done, obviously reading, to deliberate and discuss. So, excuse me. So this is a proposed order on reconsideration. It says, I'm sorry.
We need to make sure we're recording this.
Oh.
Scale it and record it. I'll just put it after we're here for it.
Sure.
Okay, it's being recorded. Okay, we'll go back through briefly some of the introduction. We didn't have the recording on. We now have that on. But this is a hearing on an application for reconsideration by both City of Idaho Falls and Johnson Legacy LLC and by Johnson Legacy LLC. We've all three commissioners, Commissioner Radford, Commissioner Christensen, Commissioner Reed, are present. We've got Weston Davis, our legal counsel here, who's put together, based on the record and the detailed requests, some proposed orders of reconsideration, which he was just getting ready to read into the record.
Right, and I'll do that now. Commissioner Christensen, if it's okay, I just quickly wanted to remind the commission, I recognize it's a little unorthodox for me to appear and present these, but considering the circumstances of Commissioner Radford's term ending today here in a few minutes, which I understand we need to wrap up quickly for that, I've got this here as a proposal for the commissioners for you to consider. So I'll go ahead and read that into the record. So this is entitled Order on Reconsideration. In response to the Bonneville County Commissioners November 30th, 2020 findings of fact, conclusions, and decision pertaining to a rezone request on property located at the end of 33rd North and located east of the Snake River, Bonneville County, Idaho, and owned by Johnson Legacy LLC, Bonneville County. I don't know if Bonneville County should be in there. Bonneville County has received a request for reconsideration of the rezone decision of Johnson Legacy LLC's property filed by the City of Idaho Falls. The Commission issued a written decision on November 30th, 2020 regarding a property owner's Johnson Legacy LLC, that's in parentheses, application to amend the existing zoning of approximately 117 acres of real property from an A1 zone to an RA2 zone. This commission granted the applicant's request zone change subject to certain conditions. On December 17, 2020, the City of Idaho Falls, through its services director, submitted a letter notifying Bonneville County of the city's intent to file a motion for reconsideration, which it eventually did on December 24th, 2020. Motions for reconsideration must be submitted within 14 days of the date of the written decision, and the county commissioners have 60 days to make a motion on make a decision on such a motion. That's Idaho Code Section 676535, subsection 2B. Land use decisions are reached and entered in a public manner after proper notice to the public. The county is not required to send notice of the written decision to any person or individual that may be affected by the decision. Instead, the county's only obligation is to send a copy of the decision to the applicant. In this case, the written decision was adopted in open session and issued on November 30th, 2020. Therefore, the City of Idaho Falls' motion for reconsideration had to have been submitted on or before December 14th, 2020 to be considered timely. Additionally, any motion for reconsideration, quote, must identify specific deficiencies in the decision for which reconsideration is sought, end quote. That's Idaho Code 676535, subsection 2B, period. There are no placeholder notices allowed for forthcoming motions for reconsideration that may eventually meet the statutory standard for reconsideration. In this case, the City of Idaho Falls untimely filed a notice of intent to reconsider on December 17, 2020, which does not identify any specific deficiencies in the Commissioner's decision. Further, the identification of the alleged deficiency was not filed until approximately a week later on December 24th, 2020. Thus, the City of Idaho Falls cannot argue it filed its motion for reconsideration until the date the alleged specified deficiencies were presented, which was not until December 24th, 2020. Either way, both efforts were untimely. Because the City of Idaho Falls did not timely submit a motion for reconsideration, its motion for reconsideration must be denied. Furthermore, having failed to timely submit for reconsideration, any request for judicial review that may follow from the city should likewise be denied for a failure of the city to exhaust its administrative remedies pursuant to Idaho Code 67-65-19, subsection 5, 6521, subsection 1D, and 6535, subsections 2 and 3. And then I have a decision regarding order on reconsideration. Based on the foregoing reasons, it is the Bonneville County Commissioner's decision that the applicant's request for order on reconsideration is denied. Looks like I need to change the date on that. And then there's a spot for the three commissioners' decisions together with the notice of the takings analysis and judicial review. And I can read that in to the extent the commission's interested in me doing that, but I know we're time strapped, so.
Beyond the decision. Okay, thank you. Do we have any questions? Any suggested changes?
I just had one question. So when I went back and reread Brad Kringer's letter on December 17th, it seemed that he was a bit unsure of the dates for reconsideration, the dates for appeal. The only question I've got is, did our planning and zoning staff give misinformation to the City of Idaho Falls in regards to their dates for reconsideration or appeal? And even if they did, does it have any bearing on this decision today?
So good question. First of all, we need to distinguish between what reconsideration and appeal is. A motion for reconsideration must be filed within 14 days. An appeal could be considered one of two things: an appeal to the district court or a request for judicial review. Okay. So when anyone calls and asks us for that information, our response typically is, we don't give legal advice. You'll need to speak with your attorneys and figure that out yourself. The reason why we do that is really to protect people from getting misinformation or potentially getting misinformation from county employees. Because there's Supreme Court case law that says that individuals or representations that are made by county employees aren't necessarily binding on the county. And so that's kind of a difficult question to answer, because even if that had happened, and I don't recall that it had, but even if it had happened, any representations that may have been made by planning and zoning wouldn't be binding on the county anyway. And those individuals who want to exercise their rights of appeal or reconsideration are free to contact an attorney to determine for themselves what their rights are under reconsideration and appeal. Does that answer your question?
Yes, it does.
Can I make a comment on that too?
Sure. Well, it's your meeting.
Oh. I mean, it's a little concerning when the staff member from the city contacts our staff member when they're represented all the way through these hearings by legal counsel. I'm not sure how appropriate that is, but when I reviewed the email on that, I think Austin Black was correct. You have 28 days to file an appeal. But that's the value of having your attorney talk to our attorney to clarify what type of what an appeal is. So yeah, that is a little concerning to me. You know, I hope that process is cleaned up in the future. So
I just had one other comment if I could, Mr. Chair, and for the record, I reread that same email that Commissioner Reed is talking about. I couldn't find any deficiencies specifically identified in that email. So according to that section in Code 676535-2B, the deficiency, if it's not identified, doesn't constitute a proper request for reconsideration.
Right.
okay, so with that,
Yeah, I'll make a motion.
floor is open for a motion. A motion to what?
I think with the change of November to January 11th, 2021, on the second page, dated this 11th day of November, it should say dated this 11th day of January 2021. Make a motion to approve.
So is it okay to cross that out and everybody initial that?
Absolutely. While we're making motions, and I'm not in a position to do that, can I correct myself, Commissioners, at the introductory paragraph? It says, "and owned by Johnson Legacy." There should be a comma after legacy. And then I don't know why Bonneville County is kind of dangling right there. That doesn't make any sense to me.
I make a motion to scratch that too. Second.
Right. There's probably other grammatical errors. I did my best.
Changes, Mr. Chair, I think let's move this through.
And those changes being changing November to January
And
and scratching Bonneville County.
on the first.
I'll second.
A motion is second, all in favor?
Aye.
Aye.
Aye. Okay, and when I pass this around for signature, make sure the initial will change it. Okay, the second order of business is the reconsideration from Johnson Legacy LLC.
So Commissioners, I have a proposed decision on that, if I may approach and present that. Are you ready? Okay, this is a longer decision and we have even less time to hit the 9:30 time frame. So I'll just go ahead and start reading if that's all right with you. So this is on Johnson Legacy LLC's decision or request. In response to the Bonneville County Commissioners, November 30th, 2020 findings of fact, conclusions, and decision pertaining to a rezone request on a property located at the west end of 33rd North and located east of the Snake River, Bonneville County, Idaho, and rezoned by Johnson Legacy LLC. And then again, it says Bonneville County. We need to pull that out. Bonneville County has received a request for reconsideration on the rezone decision of the Johnson Legacy LLC's property. This commission issued a written decision on November 30th, 2020 regarding a property owner's (parentheses Johnson Legacy LLC) end parentheses application to amend the existing zoning of approximately 117 acres of real property from an A1 zone to an RA2 zone. This commission granted the applicant's requested zone change subject to certain conditions. David Johnson, on behalf of Johnson Legacy LLC, filed a motion for reconsideration, which was received by this commission on December 16, 2020, 16 days after the written decision was entered by this commission. Motions for reconsideration must be submitted within 14 days of the date of the written decision, and the county commissioners thereafter have 60 days to make a decision. See Idaho Code 676535 subsection 2B. Despite the public nature of the decision being reached, the county is also required to send a copy of the written decision to the applicant along with notice of certain rights available to the applicant. And that's Idaho Code 67-6521 subsection 1D. Unfortunately, a copy of this decision was inadvertently not sent to the applicant until December 4th, 2020. As a result, the applicant's rights to file a motion to reconsider was necessarily told until after the county complied with its statutory obligation of sending notice to the applicant. Accordingly, the applicant's motion for reconsideration is deemed to be timely. You understand the distinction there, Commissioners? Okay. This commission will address each of the applicant's requests for reconsideration individually. Conclusion number 5. Excuse me. Applicant suggests the Bonneville County Commissioners mandated a 5-acre minimum lot size. This is not correct. Instead, the commissioners held the total lot size average, and I put that in bold, must be maintained at 5 acres. And that was also in quotations. The total lot size average must be maintained at 5 acres. As a result, the commissioners have not foreclosed the option petitioner may have of clustering property in conformance with this requirement in the future, which could allow for smaller lots along the river and larger lots. I've got a subsection A in there that needs to be deleted. So I'll start back over, which could allow for smaller lots along the river and larger lots more inland as suggested by the applicant, which properly planned would also reduce the cost of the applicant's infrastructure. So just as an aside, commissioners, this is could, not shall, so that may be determined at some time in the future. I just wanted to be clear on that. Point number 2, conclusion number 6 and finding of fact 7. Applicant has stated the requirement for development conditions numbers 1, 3, and 5 are not reasonable for the following reasons. Condition number 1, applicant asserts it does not own any property adjacent to 33rd North to upgrade 33rd North, and that such a requirement to improve the existing roadway is unreasonable. The county does not expect the applicant to perform upgrades on the existing 33rd North, except to the extent 33rd North may actually extend onto the applicant's property in the applicant's future development of the subject property, which will include Lucille Lane. Bonneville County owns the underlying ground for the existing roadway identified as 33rd North and will continue to remain responsible for the development and improvement of the existing roadway. As a result, any expansion to meet county specifications should not be at issue, as all developers are expected to meet county right-of-way and development standards. Furthermore, it is clear that the only access the applicant has to a public right-of-way is through parcel number RP 0237 E017032. Providing access to a public right-of-way is part and parcel of the applicant's request. Otherwise, the property would be landlocked. Thus, it is only feasible that applicant provide access through 33rd North, and the applicant may be responsible for any corresponding upgrades pertaining to the applicant's property. Volunteering future access through property that is not presently platted for a public right-of-way, parentheses, such as a future connection that may lead to Heritage Hills subdivision, and parentheses, would be misplaced. Point number, what is this? Subpoint number 3, under condition number 3. Applicant has stated that centralized water and irrigation is cost prohibitive. However, applicant has failed to identify how, in light of the possibility of clustering, these requirements.
I've already got a search warrant signed by a judge.
I'm getting some feedback.
Ruby.
Okay, all right. Let me read that last sentence again, and I know we're running really short on time. However,
We started 5 minutes late, so.
okay. However, applicant has failed to identify how, in light of the possibility of clustering, these requirements are cost prohibitive. Condition number 6, applicant has referred to glazing which is presumed to have actually intended by context to be a reference to gliding or the glide path. I didn't understand what glazing meant. I apologize, commissioners. If it's a term of art, maybe we need to correct that, but I presumed it was a reference to the glide path. To the extent this was the intended argument, this is only a suggestion. The county used the word, or parentheses, the county used the word, quote, encourage, end quote, and parentheses, for the applicant to cooperate with the city of Idaho Falls in this regard. It is not a requirement. And then as a final thought before the decision, additionally, the granting of an RA2 zoning as requested by the applicant allows for a greater density of housing than the prior zoning afforded to the applicant. And then I have this language, a decision regarding order on reconsideration. Based on the foregoing reasons, it is the Bonneville County Commissioners' decision that the applicant's request for order on reconsideration is hereby denied. Again, with a spot for the commissioner's signatures and regulatory takings analysis with rights of judicial review. So,
one point, going back, second bullet on the second page said, thus it is only feasible that the applicant provide access through 33rd North, and that the applicant who said may be responsible. The wording says be responsible, which I think is what the practice and standard of the county is.
Oh. I'm sorry, I misread that.
Yeah, developers are responsible for road improvements in their subdivision. Just wanted to clarify that.
Right, yes, it does say, and that applicant be responsible for any corresponding upgrades. I misread that, I apologize.
Okay, questions?
Mr. Chairman, I just might make a comment. A couple of things. First, I appreciate the work of Mr. Davis, but secondly, on that last sub point, just for the record, me personally, I hope it's a strong suggestion for the applicant to cooperate with the city of Idaho Falls, because there are some real important issues here. And I just personally hope that they can be worked out to satisfy both people and to protect the airport while still protecting the rights of that property.
And I think those sentiments are shared by at least this commissioner.
And me too, I'd say, and I would note that we need to change the date again to January 11th if we adopt this instead of November. Okay, Mr. Chair.
So, Mr. Chairman, if you're ready for a motion, I would move that we adopt the findings of fact, the order as presented, with the corrections noted, deleting Bonneville County in the first paragraph, deleting the A in the first bullet point under the applicant's request for reconsideration.
Right, conclusion number 5 is where that's found.
Okay, conclusion number 5. And then the date change is noted by Commissioner Radford.
I'll second.
Okay, we have a motion and a second. All in favor?
Aye.
Aye.
Aye. Okay, question for our attorney, would it be better for us to reprint these and sign them with the corrections or just initial?
You can just initial the changes. It's, I think that's made into the record, and you'll only have one signed copy. It's really a preference issue for you.
And before we adjourn, just want to take a minute to thank Commissioner Radford for 18 long years, dedicated services. This type of work isn't for the faint of heart, and we've enjoyed working together with him for at least another half hour.
Yeah, I really enjoyed it, Mr. Chair. I thought Lee Staker was great to work with too, and I'll always feel that way, but it's been a pleasure to serve with both Brian Reed and Commissioner Christensen. It's gone by really fast. In a lot of ways, it's gone by really fast. So I'm really grateful to have worked for the county, and I'll always be grateful for this experience. I'll always treasure it forever. Thanks, Mr. Chair.
So I'm guessing that kind of makes it like part of the congressional record. But anyway, thank you. With that, we stand adjourned. We need to get the chamber prepared for this one again.
Thanks, Weston.
Thank you.
Hope to see you along the pathways of life again.